Good afternoon, everybody. Thank you for joining us today for our webinar. It's for the Snowbirds. Should I stay or should I go? My name is Brian Tully, and like we always do with our webinars, we're going to give everybody a couple of minutes to join us. So hang in for just a minute or two, and we'll be back and get started. Okay, everybody, we're back and we're going to get started. So again, thank you for joining us. Our topic today is for Snowbirds. Should I stay or should I go? Working through the estate planning and domiciliary considerations for New York and Florida. Fortunately, we are joined today with or by Aaron Millman, who is an attorney and a CPA down in Florida. So he'll be joining us and dealing with the Florida components while I'll be working through the New York side of all this. For those of you that don't know me, my name is Brian Tully. I am a certified elder law attorney here in New York, the founder of Tully Law Group. It's been 25 years that we've been practicing elder care and estate planning and helping seniors at their legal concerns, their financial concerns, and their elder care concerns. And we do all we can to advocate and make sure people can protect the most assets, can get Medicaid benefits as needed to pay for care, and to help people get the best care, help your loved ones get the best care possible. As I shared, I'm joined by Aaron Millman down from Boca Raton, Florida. Aaron, I'll give you a minute, please. Just introduce yourself.
Sure. Hi, everyone. Nice to meet you, and happy to be here today. Happy to be a part of the webinar with Brian and the Tully Law Group. I have been a practicing lawyer here in the state of Florida for just over 12 years now. We have our own practice, the Millman Law Group, where we have a couple of attorneys and staff, and we help people again with all aspects of estate and trust planning, elder care, long-term care planning, and estate and trust administration, primarily in the South Florida area, but we help people all throughout the state as well. So happy to be here and happy to provide some context as it relates to Florida planning.
It's funny, we get a lot of questions here in New York about Florida and moving. I'm sure we get more questions about us moving to you than you get moving to us.
Yeah, we get a lot of that. I mean, of course, we get a lot of people coming down here, or we call it like the toe dip. They start down here, they buy a place, they come down for 1 month, then it's a few months, then they want to make residency.
Sure.
And in fact, sometimes we see people going back up north.
Sure.
In that case might be when they do get older or something happens to one spouse and they're going to go live with the kids and that sort of thing as well.
Understood, and that makes sense, and we do see that too. All right, so as we get started here, any questions that you have at all, please put them into the chat or the Q&A box, and we'll be happy to answer them later at the end of the webinar. Also, I like to make sure you can see us and hear us and see my screen. We won't always have the screen share up there, but if you can, somebody can let me know in the chat box that you can hear us, see us. All right, thank you, Steve. All right, good. So let's get started. First things, I want to share with you the agenda. So what we're going to be covering today are, we just did point one, right? So we're going to cover domiciliary requirements because there's different tax issues, which we're going to talk about a little bit in a little while. So what's required to be a Florida resident versus what's required to be a New York resident. We'll talk about estate taxation. We'll talk about estate planning documents. Some of them are different between New York, or at least the content and the execution requirements are different between New York and Florida. We'll talk about probate and how to avoid that. Then we'll get into asset protection, typically the use of the irrevocable trust. And ultimately, we'll talk about long-term care. It's our plan to cover this in about 40 minutes and answer any questions that you have and wrap up by 2 o'clock. If we go a little over, that's all right, all depending on the questions, all right? And of course, if we don't get to your question, or if you have additional questions, you could always reach out to Aaron, or his firm, or my firm. We'll have our contact information at the end, okay? So first things first topic we're gonna get into is the domiciliary requirements. At this point, I'm gonna stop screen sharing, and it's gonna be Aaron and I talking about this. So again, most people, the way we'll work it is New York, and then Aaron will go after that. Most people do not go from Florida to New York unless it's, as he said, the toe dip, or it's the return back afterward.
Yeah.
But I think bottom line for both of us is domicile. A person's domicile is where they intend to live, where their permanent home is. Okay, so for New York law, to be a New York resident, a New York domiciliary, New York has to be your permanent home. It's where your permanent home is located, and it's the place where you intend to return home after vacation or business assignments or military assignments, okay? So that's domicile. With residency, that's more about taxation. And you're taxed as a New York resident if New York is your domicile, or you don't have New York as your domicile, but you spend at least 184 days here. So you might have a domicile in Florida or another state, but if you're in New York for 184 days or more, then New York is going to tax you, all right? Income tax, all right? So that's important to realize. How does that work down in Florida?
So good point. So what I like to tell people is Florida doesn't actually care if you're a resident. Why is that relevant? Because Florida has no, we'll get into the taxing, but they don't have any state income tax, capital gains tax, estate tax. So why do they care whether you are a resident or not? Now,
Okay.
A lot of people come down here and, their friends or their neighbor or the family member says, you've got to spend 6 months in a day and 1 day in Florida to be a resident. Well, that's actually, they say that, but that's actually backwards, right? Because if you're here 6 months in a day, then you're not in New York for 184 days, right? So now you've just overridden that test. But at the same level, if you're in Florida for 5 months, if you're in New York for 4 months, and you're traveling in your RV for 3 months, then you can be a Florida resident, right? Because even though you haven't spent 6 months in a day here, you've avoided spending the 184 days in New York. And what I like to call that is like the bright line test, right? Okay. So if you're in your Brian, New York for 184 days, you're going to be deemed a resident, no questions asked. And if you aren't, but you have, situation, right, where you are kind of doing this back and forth thing, then we kind of get into like the subjective factors of domicile and, where's your driver license? Where are you registered? What, temples, churches, organizations, what would you belong to them in Florida, New York, a mix of both as well. So it's important if you do want to become a Florida, resident, you're going to spend more time here. That's what I like to tell people than New York. But beyond that, you'll get into making sure, things are, the boxes are checked to be
right. Great. No, that's actually a great point, because you're right. It's not about establishing Florida as your residency. It's about establishing New York not as your residency.
Correct. Yeah. Establishing New York not as your residency. And the people that do come down here, right, they say, well, will I be subject to an audit? Well, New York does have a large agency that audits, there's out-of-state audits, and they try to, let's just say, find the needle in the haystack, something you forgot to do, or some, you still had that member or resident, fishing license or something else that would create some sort of way to pull them back into New York as a resident.
Exactly. All right. And if there's any questions about that, again, because of our time constraints, we're going to outline the subject like we just did and move on to the next topic. So the next topic for us now is going to be moving into, and I got so many screens open right now. Now, because we talked about domicile, now we're going to talk about estate taxes. All right. Next topic is estate taxes between New York and Florida. So when we look at New York, um, I'm already not liking this, where this is going. The and everybody, all of our viewers, we talked about the weather before we started the webinar, and you can only imagine already. I think he's already up by 2 points. So when we talk about estate taxes, when I sit with clients here in New York, we're confronted with two estate taxes that we have to deal with. First and foremost is a New York estate tax, and then secondarily we have a federal estate tax, which of course governs the entire nation. On the New York front, we have an exemption amount, which means you can pass X amount to anybody you wish without paying any New York state estate taxes whatsoever. And this year, that amount is $6.58 million. $6.58 million. Now, that means you can leave up to that amount to a trust, to children, to any person you wish without paying estate taxes. Nationwide, I believe nationwide, we have what's called an unlimited marital deduction, where you can leave $100 million to your spouse and there'll never be estate taxes. So what we're talking about is the amount that you leave to people other than your spouse. And in New York, 6.58 is the threshold. Now, the highest tax rate in New York State is going to be 16%. It is a graduated scale. Which means as the assets increase, you hit the 16% ceiling. The most important point I want to share about New York State is everybody in New York in my field was very happy, and those with assets and taxable estates was happy when the governor a number of years ago increased the threshold to 5 million, and it's gone up every year with the cost of inflation. However, in the small print of the law, there is what's called a 5% cap. So in New York State, 6.58, no estate taxes. But if you go 5% over, right? So 5% of 6.5, you're looking at about another 300 grand. If you hit 6.9, you lose the exemption entirely. So everything is taxed from $1. So if you're at 6.6, yes, you got a little bit of tax, 6.7, 6.8. As soon as you hit 7 million, for example, you're paying an additional roughly $700,000-$800,000 in New York estate taxes. Okay,
that's what people call the cliff, right, Brian?
That is the 5% cliff, and you just kind of fall right off of it. And of course, we have a federal tax, which Aaron can talk about as well. But we have a current exemption at $12.92 million. And since you don't have much to say about the state estate tax in Florida, I'll let you talk about the federal.
Yes. So the federal tax is an additional tax. Well, in the state of Florida, again, we have no state estate taxes, no state capital gain or income tax. So that's why people like that environment. In fact, people sometimes ask, how does Florida, just interestingly, raise revenue if they don't have income taxes, right? So a couple things are, of course, we still have property taxes and your local sales tax. And we actually derive a lot of revenue, interestingly, from tourist taxes. So if you go to, take the family to Disney World, on your hotel receipt, there's going to be a tourist tax, a bed tax, all different taxes, minor, but we tax a lot of out-of-staters who come here, and we raise revenue that way. So for federal tax purposes, we still follow it. Right now, the exemptions are the highest they've ever been. It's about $12.9 million per person, which equates to about, you can share it between husband and wife, about $26 million. So, many clients are under that level. We do have some clients that are over that level. We need to deal with matters. Also, just to note, and this doesn't come up too much, but if say you came down to Florida, but you retained a piece of real property in New York, you want to be cautious, of course, as long as the property is under the cliff up there, you're going to be okay. But if you happen to own that $7-8-9 million house, there are plenty of properties there in that arena. You got to watch, possibly some planning for taxes in that state where that real property is as well.
So if you're not a New York resident, if you are a resident of Florida, right, domiciliary of Florida,
yes,
and you own real estate in New York's still going after you.
Still going to go after you for the value of that. But again, that's why the cliff is important, because if it's $1 million, $2 million property, again, you're not going to meet the threshold for New York taxes. So you'll avoid that 16% or so.
So if the vacation home is in New York at 10 million, you're getting hit with the New York estate tax on that.
Yes, because of the real property there. And I think, and we'll get to this in a later part of the webinar about estate planning and avoiding some probate issues as well.
Yep. Good.
Do on that
Good,
separate
good,
front.
good. All right, cool. All right, so that is the estate tax situation. And again, sharing my screen here to show where we are. Our next topic is going to be estate planning documents and the difference. Sorry, I was looking at a different slide. So we're going to get into the basic estate planning documents at this point. The ones primarily in New York, whenever we sit with a client, regardless of age, regardless of health, regardless of how much money they have as a net worth, we want to make sure we have 4 basic or foundational estate planning documents in place. A very important point, though, regardless of where you are, in order for an estate document to be signed, there has to be a requisite level of capacity. So these documents should be in place, quite honestly. Every adult over 18 years of age, as I tell people, I've got 2 kids in college, they have most of these documents in place. So first thing is you need to have capacity. Now, the 4 documents that we talk about, last will and testament, what we call a durable modified power of attorney, a healthcare proxy, and a living will. Okay. Now, real brief, the last will and testament is the document that will distribute your assets that are in your name solely when you pass away through the next topic we'll be talking about, which is called probate. Now, here in New York, you have 2 witnesses to a last will and testament, and you have a witness affidavit that gets signed by those same 2 witnesses, and that affidavit has to be notarized. It's an attesting affidavit stating that the witnesses were there, that the testator had capacity, could read and write English, and so forth. So that's the execution for the last will and testament. How does it work down in Florida?
Yeah, I mean, essentially, it's the same. We need 2 witnesses and a notary to formalize and complete a will. Basically, we have a self-proving affidavit.
Right.
And just to your point, Brian, and just because this is a question we get asked all the time, they'll say someone will come in and just on a general basis say, I have New York documents. And some people come in and say, I heard they're valid. Some will say, I heard they're void.
Yeah.
My overarching statement is they're still valid. They're not void because you have moved. But many, many, many times we recommend people update these for various purposes, including if you might be someone that might be subject to an out-of-state audit because you chose to move here. One of the questions is going to be, what county and state govern your estate planning documents? And if it still is New York, you've got to answer that appropriately. But if you had a relative or someone with a New York will that passed away here in Florida, we can admit that will to probate, provided we have an affidavit from an attorney like Brian saying this was validly executed in accordance with New York law.
Understood. Okay, good. But you do have to have 2 witnesses on the will itself.
2 witnesses, and then to prove, yes, and a notary as well.
Got it.
Yes.
Got it. So the notary is required for the testator's signature at the end of the will?
Say that again, Brian. You froze.
Sorry, the notary is required for the testator's signature.
It's not required for the testator's signature.
Okay.
It's required to self-prove the will. What that means
Same
is,
thing as us. Yeah, good. So it's for the witnesses and the self-proving affidavit. Okay.
Exactly.
Now, the next document is going to be the power of attorney. A very common descriptive word is called a durable power of attorney. And this is where you can appoint 1 or 2 people, perhaps in New York, to handle your financial and legal affairs. Whenever I'm talking about a power of attorney with a client, I also use the word modified. The power of attorney in New York, as it's written within the statute, is not sufficient for aging. It is not sufficient for asset protection or income protection or even taxes. So every power of attorney that we prepare for a client in dealing with their estate planning has to be durable and modified. Okay. Now, the actual principal's signature has to be notarized and witnessed. And then the agent has to sign as well, and that has to be notarized. Okay, so again, witnesses and notarizing is required. Now, also in our power of attorney in New York, we list powers, and they're all covered by brackets and parentheses as to what kind of powers you're giving to your agent to help you with. And I think there is a difference between New York and Florida here, in that in New York, we're able to say, this bottom power, I'm initialing this to cover all the above ones. So we're able to cover like 3 pages of powers with 1 set of initials. So how does it all work in Florida?
Right. Again, in Florida, again, I mean, and to Brian's point, we don't have something called a modified power of attorney, but I'll just say I think the power of attorney is probably the most important document for aging, for yourselves, for your
100%.
parents, for anybody else. And,
Yep.
and the other thing I'll say is, even though a power of attorney, whenever it was executed, is valid because it was executed appropriately, many banks, many institutions, as you'll find, they don't want to accept your 23-year-old power of attorney from another state. They'll say, we deal with the last 3 to 5 years it needs to have signed. We also had legislative changes in 2011, which basically said that you have to initial next to certain we called superpowers. These are like similar to what you're saying, Brian, that give estate planning, Medicaid, long-term care planning powers. Very, very important. The power of attorney specifically to requirements are you need to sign it, you need to have 2 witnesses, and then you have to have a notary who's notarizing the sign or the principal's signature as well. If necessary, you can use an interested party as a witness. You don't have to have an agent sign a notarized acceptance, but if they start to take action, then they could take action right away. I don't know about in New York, but in Florida, we modified all our powers of attorney now take effect immediately. It used to say it's sprung upon incapacity, and that became incapacity is a very vague term, and they just kind of X'd that.
100%. So statutorily, they're all effective immediately.
They're in effect immediately.
Okay,
yes,
so
yes.
so New York still has a springing power of attorney form, which is not effective immediately, but only becomes effective if the event occurs, which is incapacity of the principal. We don't like them. We don't use them for the exact reason New York, Florida has knocked them out altogether, because you're going to need a certain number of doctors to qualify that person as incapacitated. And if you have things that you need to do, are you at that point, and what doctor is willing to say that based?
Exactly.
So, all right, good. I'm glad Florida did that, but we still have that as an option in New York, but we don't recommend it. Okay. And to clarify again, if a New York power of attorney can be valid and can be utilized in Florida, as long as all of those superpowers or modifications are specifically initialed.
Yes, absolutely. Yes.
Got it. Okay. Now, also to your point, as you said earlier, I have clients that, and I just told you about one before we jumped on the call, where there are New York documents in place where they'll be moving to Florida. My advice is always to sit with an attorney in that state just to have them reviewed. They're valid, but there may be a certain intricacy or nuance that state may want that we don't do in New York. So it doesn't mean you got to redo everything, but you got to at least get it looked at, right?
Absolutely, absolutely.
All right. Now, after the power of attorney, we get to we have 2 healthcare documents. One is going to be a healthcare proxy, and the other is the living will. The healthcare proxy is where in New York, the principal can appoint one person at a time to make healthcare decisions if the principal is not able to make those decisions themselves. It's procedures, it's anesthesia, it's a lack of capacity, it's aging. There's a whole host of reasons why a person may not be able to make a decision for their healthcare procedures. And it's through that healthcare proxy where you can pick and order 1, 2, 3 people. We do in New York have a backup law. It's called the Family Healthcare Decisions Act, where there's a priority of people. So if there's no healthcare proxy written, then it's a spouse, it's a child, and again, there's a priority of people. Healthcare proxy, though, is certainly the cleanest and best way to do it. For example, if you've got 4 kids and you want the youngest one to do it, you want that in writing. Now, the living will, in New York, the living will is not by statute. The living will was created by the courts. And the living will doesn't appoint anybody, but it's a statement that says, if I'm ever in an irreversible and incurable condition, I do not want any medical treatments to keep me alive artificially. So it's the end of life statement saying, I don't want the machines. So in New York, the way we work it is it's 2 separate documents. There are plenty of practitioners that put them together as one document. How do you handle it down there, Aaron?
Yeah, I mean, so a lot of similarities. I mean, we do what we call as a healthcare directive, which basically covers your healthcare proxy, HIPAA authorization, which is the Health Insurance Portability and Accountability Act. So that's the release of medical information.
Sure.
And the living will. I think the biggest difference is we can appoint multiple agents. So you can say my spouse or my child. You can say they can act together. I don't like to do it that way. I think that becomes a burdensome, and especially if someone's there or not. So I like to do what a lot of people like, I really want my 3 kids to make the decision. I'll say, we'll sometimes put like the 3 kids either or, and have a separate side document that says, when any of you are serving, I want you to act basically, together.
Okay.
And we've put the living will into the healthcare document just so that there is a person named who can make, ultimate decisions under the law. And again, the healthcare power of attorney would take effect immediately. We do not require a notary. It just requires 2 witnesses.
Right.
And where people sometimes get confused is the last thing is is this a DNR, a do not resuscitate order? And for us, a DNR is a state form. It's a 1-page form that the hospitals, doctors' offices give out, that you do not want to be resuscitated. And so I like to say, don't sign that now. Your proxy is allowed to sign that under law if you're in that, state that might be necessary.
Understood. Great point. I'm glad you brought that up, because people do, when they hear the living will language, end of life language, they'll say, is it a DNR? And it's not. So in New York, that's a doctor reviewed and signed form with the actual patient. And interesting on the proxy, you can have more than one agent. Interesting.
Yes.
So what we're finding, and I'm going to relate back to the power of attorney as well. So in the power of attorney, the financial document for New York, you're allowed more than one, and you can designate like you can, whether it could be separate or together. But what we just started running into more and more on the financial power of attorney is that banks won't accept the power of attorney if you have 2 people. They want just one person.
It's true. That's true. Right. And people say, well, I'll say, well, banks can also keep in mind, everyone that's watching, banks can have their own rules. And if you don't comply with that, then, they'll say, well, sorry, we can't, keep you here, keep your money here, if that's the case. But that's true. They don't want the liability. They don't want 2 people signing checks. So I try to steer from that to the best we can, but you technically our laws do allow that. So, we try to guide people as best we can there.
Great. Good point. Now, the other estate planning document that we often implement is a trust, and we're going to talk about it. There's different types of trusts. In New York, there's just a notary requirement for a trust. There's no need for witnesses. How about in Florida?
So it's a little technical. I mean, technically you can create a trust with just the notary, but if you wanted to have any effect at your death, meaning what's called the testamentary aspects, meaning when I die, here's something split, you want to have you need the same signature requirements as a will. That's the 2 witnesses and a notary as well.
Okay, very good. Very good. Thank you. All right. So that is the documentation for estate planning documents. Now we're going to move into the topic of the probate process and avoidance strategies. Now, so far, look at this. I'm remembering to keep showing the slides. I'm doing
That's good.
And again, just to remind the audience, if you have any questions at all, please go to the Q&A box, enter your questions there, and we'll give contact information for Aaron and myself at the end. So looking at the probate process and avoidance of probate. So again, there's going to be similarities here, but probate is a proceeding in New York and other states which can be avoided. But for some people, for a lot of people, it's required. Probate in New York is what's called a validity proceeding. It's where a judge has to review the circumstances or the will, last will and testament, if it exists, and determine if that will is valid. Probate is or can be a 6 to 8 month process. It could be a much longer process. There's court fees in probate. There's legal fees in probate. There's a complete lack of privacy in probate. Everything filed in the New York surrogates court is public, and there are literally companies that go in and harvest that data, which we don't want. In addition, and finally, probate opens the door to family members, all right, certain family members having the ability to go to the judge and really contest. So bottom line is, we like all of our clients to avoid the courts in every single scenario, and probate is no exception. So generally speaking, we want all of our clients to avoid probate in one of 3 ways, either through joint accounts, joint survivorship accounts and assets, or through beneficiary designations, or through the use of trusts. So if all of your assets have beneficiaries or joint with survivorship owners, or owned by a trust when you pass, and nothing is solely owned, then you've avoided probate. One of the best ways that we have that, which we can talk about next a little bit, Aaron, is the revocable trust. But talk to me a little bit about probate.
Yeah, I mean, so everybody has this notion probate is terrible in Florida. Now, we got a couple issues here. One being, we don't have any, and I don't think New York does any like small estate affidavit or form.
We
basically
do.
every
Yeah.
okay, we
50,000. Yeah. Yeah, yeah.
Okay, so every dollar you have that is frozen, that doesn't have a joint owner, that does not have a beneficiary, or is not part of a trust, goes through probate in Florida, is required to do so. Now, there is a shortened form if you're under $75,000 in assets subject to probate, but it's still a court process, a judge is
Mhm.
involved, and that sort of thing. Now, it used to be, at least for us, pre-COVID, we'd have to go to court for, to open an estate and to really move anything along. That process has gotten smoother because we're able to submit things to a judge via portals. So we don't charge clients time for going to court for them, and things tend to move faster. Now, a lot of people come in and they have this notion that probate, the state is going to get 3% or 6%, or the state gets money. That is not true, but that is derived through the fact that we do have presumed reasonable fees for probate. Now, that
Mm.
it is more or less involved if there was a contested estate or the attorney was named in the estate and took, for example, our presumed personal representative fee is 3% of the estate. So if the estate was $1 million, the presumed reasonable fee would be $30,000.
Mhm.
That's not to say the attorney gets that, or the representative. The attorney can always contract with the client to bill on an hourly basis, to bill on a different basis.
Mm.
So the state doesn't get any money. It just deals with that, how that's done. I mean, I always tell people a summary administration can move fairly quickly. You could probably be done within a 2-month time frame.
Right.
But for a formal estate, because we have a creditor period of 3 months and everything else, it's 6 months to a year, if not more, and assuming things move along as well. So it definitely does take a longer time with
Right.
more costs and expense.
Absolutely, absolutely. So 2 other points. Wherever there's real estate, there has to be probate. So unless it's owned jointly, or in some circumstances can be crafted with a beneficiary, some type of title change, or it's owned by a trust. So if we have clients in New York with a condo in Florida and property in North Carolina, all in the decedent's name solely, that is a primary proceeding, probate proceeding in New York where the person resided. And then we've got ancillary proceedings in North Carolina and Florida. So there are certain red flags, which I'm sure Aaron and I would agree, where probate really needs to be avoided. For example, real estate outside of your home state, disinheriting a child perhaps, or not having any heirs or distributees, as we call them, that are local or nearby or at all. So in that case, we're certainly going to talk about what's called a revocable trust. There are 2 main types of trusts that Aaron and I use. One is the revocable and one is an irrevocable. They serve different purposes. For the purpose of probate avoidance, and depending on a person's net worth and estate tax situation, we may just rely on a revocable trust. That is an entity created by a written agreement with a grantor, creator, and a trustee. In Florida, you might use a different term for the grantor or settlor. And that agreement creates an entity that can own the real estate. Now, it's completely revocable, which means the client is the creator of the trust, the client is the trustee, the client is the beneficiary, and they can amend it and revoke it at any point in time. The sole purpose of a revocable trust is to avoid probate. There's no asset protection whatsoever with a revocable trust. Any differences down there, Aaron?
Yeah, I mean, pretty much for most clients, we set up a revocable trust, and and we'll get to it. But a lot people oftentimes ask, what's the difference between a revocable and irrevocable trust? And of course, you could be a smart aleck and say one is revocable, one isn't. But in all reality, I mean, going back even to the estate exemptions, if you're someone in that arena between 1 exemption and 2 exemptions, there's some tax planning you can use in revocable trust planning to maximize the use of exemptions. But the bigger thing is to avoid probate. And people want to avoid probate. Again, we say it's not asset protection, but this is probate and protection. So if you have a trust and you name your child as the trustee, if something happened to you and the house is in the trust, and the Florida house, the New York house, North Carolina house are on the trust, they can basically take over, and start dealing with that asset almost effective immediately.
Right.
And so, we like people to have trust planning because the family's happy, things get settled on a much smoother basis. And again, if you have a New York trust and you come to Florida, we can do something like amending or just restating that trust for Florida law. so you don't need to go back and retitle your house or other
Right.
property that's in that trust as well.
Great point. Great point. But it's a very commonly used tool. Um, Years ago, I was very comfortable with probate, and with the delays since COVID, the courts being shut down, with identity theft and fraud, with the public proceeding here in New York, we are recommending strongly that people do everything they can to avoid probate. Obviously, there's some couples or clients that don't require the trust, and they'll have a will-based plan, but we want families to stay out of the courts. There's no reason to do it.
Of course.
All right, so good. Any questions on that, folks? Again, go to the Q&A box. But now we're gonna move on again to our next topic. And we just discussed this one. Now we're moving into a different type of trust. It's what's called the Irrevocable Asset Protection Trust. Now, we use these trusts quite frequently. And the reason we use these trusts is because we're working with a population that's getting older, clients over 50, clients over 60, clients over 70, doing their planning for their families, for themselves. And what we're looking at is our next topic is going to be discussing long-term care. But as people get older, there may be a need for care. There may be a need for an aide to come in to assist with what's called the activities of daily living, or there may be a need for an assisted living facility, or even, God forbid, the need for a nursing home. So we look at how do we pay for that. And the bottom line is that we can pay privately, or there's some private long-term care insurance. But ultimately, folks in New York are going to rely on the Medicaid program, the long-term care Medicaid program. Now, a tool that we use very frequently is an irrevocable asset protection trust. It's one where we're able to remove the house, for example, or vacation house, third house, remove out of the client's name, place into this asset protection trust so that Medicaid is no longer able to count it as an asset of theirs. And again, once we get to more about long-term care, we'll talk about a little more of the intricacies. But the trust itself is built for asset protection. In New York, there's one very strong component that must be required in an irrevocable asset protection trust. And that is whatever is put into the trust itself can never be transferred back to the grantor, to the client directly. So if mom and dad put their home into an irrevocable trust, it stays there. They've got the right to live there. They've got the right to sell. They still pay the expenses. They still have capital gains tax benefits. So there's no reason for that property to come back into their name. It just stays there. Now, if we have a financial account, let's say $100,000 is also in that trust, that money cannot go back to the parent. Okay, so in order to gain the asset protection for this long-term care risk, we need to build a wall between the client and their money inside the trust. So we specifically say that no principal from that trust can ever be distributed back to the parents. Now, because that rule is so strict, we always make sure we leave enough money outside of the trust. So if all you have is $80,000 in the bank, you're keeping that money. We're not protecting that money. It's staying in your name so you can use it. So it's always a balancing act as to what to protect and what not to protect. But again, we use these every day, and there's thousands of homes in metropolitan New York and Long Island in these types of trusts. How about you, Aaron?
Yeah, I mean, on a similar basis, we and we'll get into some of the asset exemptions down for Medicaid, I think, in the next part. But we we'll talk to people about Medicaid asset protection trusts. Again, we do follow the same gifting rules, the 60-month or 5-year look back rule.
Right.
And there's some unique things there because, again, we have in Florida, when you get your homestead, which is your creditor protected house, also you get certain property tax deductions by doing that. There are ways to take like someone's again, mom or dad's property, move it into the trust. They can still have the right to reside there, get all the tax exemptions, benefits, and things like that. To your point too, you can allow them to still get the income from the trust if there is income derived, but you put a child or another loved one on there as a trustee, and that's one way to kind of protect the assets when you've got a single individual, or you've got want to protect mom and dad's assets together as well for this program. And, just on the note of irrevocable planning, I mean, there's other types of irrevocable trust that you probably do relates to life insurance, other things like that. And depending on one situation, it's kind of additional parts to planning and gifting and things like that we can always, discuss further with clients as well.
Great point, Aaron. You're right, because there's different clients that come in with of course different net worth and what their risks are.
Yes. Exactly.
If we're sitting with a client in this range, we're looking at long-term care because, at $100,000, $200,000 a year to pay for long-term care, they're not able to do that, and therefore we're going to need to rely on Medicaid. But if we're sitting with a client with a higher net worth, then obviously they'll have the ability to pay for the care. They're not going to be looking perhaps at the government Medicaid program. And therefore, we're using more estate tax-based trusts, like you said, life insurance and so forth.
Exactly.
Did I hear you correctly? Because Florida has the homestead on the primary residence, you don't necessarily have to put it into a protective trust like this?
Well, there's two parts to that, right? So as we get to it, like Medicaid in Florida, and speaking of the Medicaid program, which is why we're talking in that arena, if you don't live in your house, the house is an exempt asset, does not count up to $688,000 of equity. So it's a pretty decent number. If a spouse or a disabled child lives there, it's exempt, or if you still live there, it's basically exempt. But where we run into issues is a lot of people say, well, I want to have the house, but if I sell it, right, then it becomes, you just took, if it's a $600,000 house, it's now a non-exempt asset, right? You have all that money. So the benefit of the trust is that if you sell it, the money's now staying in the irrevocable
Understood.
trust.
Good point. All right. And it's funny, in New York, we have an equity exemption as well. As long as the Medicaid recipient or their spouse is residing in the house, Medicaid won't touch it. As long as the equity is below, it's like 990,000 at this point.
Okay, so you get a little higher.
A little higher there. So wait, I get 1 point. You're already up by like 5 points so far. So, but as soon as the house is vacant, all right, if the recipient isn't there, if the spouse isn't there, if a disabled child isn't there, if a minor isn't there, and other exceptions, then Medicaid's going after it. So they'll put a lien on it or collect against the estate. So we're using these all the time.
So an important thing there is, as Florida says, as long as you have an intent to return home, which is, basically a generic statement, that the power of attorney can make. So say dad's living in a nursing home, but has the $600,000 house, we can continue to exempt it. And, to add on to that, which is very unique, you can actually, that house does not have to be in Florida. So if I am on Florida Medicaid, I can exempt a place anywhere up to $688,000. We're saying that is where I intend to return home.
I just lost that point. Okay. So in New York, it only, the intent to return home only works for the primary residence. Okay. Doesn't work for a second home, doesn't work for a home you're not going back to. And it's not permanent.
Okay.
They will make a determination at some point, well, you're not going home, you're staying in the facility, and they'll lien the property.
Okay. So not the same here. So you get to pass your house down to your heirs. The Medicaid cannot take it.
Got it. But the trust still makes sense in case you sell it.
Yes, in that case. Yeah, absolutely.
Got it. Cool. Okay. All right. So that's the trust itself. Now, moving on to the next and final topic that we have, it's going to be talking about long-term care itself. So we've got a couple of bullet points here that Aaron and I are going to go through, just really comparing between New York and Florida as to how this works. So first and foremost, in New York, long-term care, as I was sharing a little bit earlier, it's about somebody needing assistance with what's called the activities of daily living. Now, in New York, we can have somebody reside within their home or child's home. There are certainly some assisted living facilities in New York. They're quite popular. And then, of course, there's nursing facilities. Do you have the same range of those three options, or do you have more or less?
Yeah, essentially we have, again, you've got at-home care providers. We've got assisted living, somewhere on the bigger, larger settings. We have the smaller group homes, the 5 to 10 person assisted livings. We have memory care. Some are standalone memory cares for Alzheimer's, dementia patients. Some are within an assisted living facility. And then we have skilled nursing care, which I tell people is also basically long-term care in there's short-term rehab and long-term care centers,
On the same building. Yeah.
Yes.
Yeah. Right. So I'm glad you brought up the memory care, of course. So New York does have the memory care, and as well as some of the group homes, the smaller facilities like you just mentioned there. Excuse me a second here. Now, the cost of care. When we're looking at New York, home care, for example, right now is where an aide comes in to assist with those activities of daily living. We're generally between $25 and $35 an hour for an aide from an agency to come in and assist. You could be at $200 to $400 a day for home care. Okay, you times that over 30 days, you could be $5,000 to $10,000 to $11,000 a month or more for home care. In New York, assisted livings are generally $5,000 to $8,000 a month, and they can certainly go higher based on memory care or dementia unit, and levels of care. So assisted livings, you got your room and board, and then generally 3 levels of care where the rates go up based on what needs there are. Then finally, if you look at a nursing home scenario, you're anywhere $14,000 to about $20,000 a month for a nursing home. And because those numbers are so significant, a lot of folks in New York are forced to look at the long-term care Medicaid program. So what do things cost down there?
Yeah, I mean, we're kind of in the same range, a little bit lighter. I'd say most private aides are charging in the $20 an hour range, and agencies about $25 an hour these days. Assisted living, various range. I'd say probably anywhere from $3,500 to $8,000 per month. Nursing homes, again, about 11,000 to 15,000. Most fall into that range of things as well. And usually, memory care is usually on the higher end of the assisted living. So $6,500 to $8,000 or so we find on a monthly basis would be a private pay rate. Got
it. So in New York, obviously, and I'm sure it's in Florida, you could use your own money to pay, right?
Yep.
Then there's long-term care insurance. And then there's long-term care Medicaid. Are there any other ways to pay in Florida, or it's really the same?
I mean, we talk to people about sometimes the Veterans Pension Program. There are some benefits
livings that helps.
What's called Veterans Aid and Attendance Pension benefits.
Sure.
We won't get into it on this webinar because there are some fairly strict requirements, but the VA can pay a pension a little over $2,000 to a veteran also who served at least one day of active wartime conflict, which we used to see a lot of World War II. Now it's some Korean War and then Vietnam era veterans as well. But on the basis of those are the kind of the big four. Coming out of pocket.
Okay. Yeah.
Your long-term care insurance, you have to really have that or get at a younger age to be paying for that. And even with long-term care insurance, we tell people you got to see what the daily benefit is, right?
I was just going to bring that up. Yeah.
So if it's $100 a day and you're looking at an $8,000 facility, you still have a gap of a couple $1,000s or so after Social Security and other benefits. And then Medicaid, I guess we'll talk about in a little bit, but that's kind of what I always think of as like the, at least it's going to save you in a nursing home setting in Florida, and then some smaller benefits for assisted living and home care as well. Good.
Is the VA benefit popular down there?
It was probably more popular. I mean, from our client standpoint, I would say before 2018, there were ways to basically gift assets and have no look back period and qualify for this benefit. Now you've got a minimum 3-year look back unless you're under, let's just use the number $100,000. It's a little more, but but so we can't just be transferring things and qualifying. So most people, I mean, we find are coming to us more or less in a crisis scenario. They don't plan as well. So we're not saying, oh, let's wait 3 years and we'll do this. They want to know how to do it. And there's more Medicaid planning tools there than VA.
Right. So so VA of course exists here as well. It's as I tell clients, it doesn't play well in the sandbox with Medicaid.
Correct.
So, and Medicaid is generally a more valuable benefit. So we usually opt for that in that scenario. All right. So now Medicaid. In New York, we have a community Medicaid program, and there's different branches of that. And we have a chronic care Medicaid program, which would pay for nursing homes. So just overview, what we're looking at is in New York, very high numbers, first time ever it's been this high. A person applying for either community-based Medicaid or chronic care Medicaid can have $30,182. $30,000 and apply for Medicaid. If it's a spousal application, it's $40,000, 40,821. Big numbers. Just last year, it was only 16,000. Okay, so they jumped it up in January and they jumped it up a little bit in February for some reason.
Does that mean the recipient can have that amount in their name?
Yeah,
Right?
that's the applicant recipient. Yeah, what's it down there?
So, okay, so interestingly, so our home and community-based services, which is your community care,
Yep.
and versus our institutional care Medicaid, which is your chronic care,
Yep.
kind of those are the programs. We still basically the Medicaid recipient still has to have under
Your
$2,000
SSI, yeah.
countable assets.
Wow.
You can use there's certain we'll talk about the tools in a minute, but that number has not changed. So it's
Another point for New York.
it's pretty low.
Yeah. So so again, I've been doing this for like 25 years. So it was about $3,000 when I started, and it's jumped up, but the last 2 years it's gone up significantly. But yeah, it's nice for the applicant Medicaid recipient to have that kind of money to work with.
Yeah.
Now on the income side, what we're looking at is a Medicaid recipient in the home care scenario versus a nursing home scenario. So in a home care scenario, a Medicaid applicant is allowed to have $1,697 in income every month, $1,697. In addition to that, the Medicaid recipient is allowed to keep any health insurance premiums that they're paying. If they have income over that, then we utilize a tool called a pooled, POOLED, supplemental needs trust. So it's an income trust that's run by a charity, very, very common, very, very popular here in New York, where we can shelter the excess income. So if a person has $4,000 in income and they require community-based Medicaid services, they keep their $1,697, they keep their health insurance premiums, and the balance, we use that pooled income trust. Gets pretty complicated, but it's a godsend, and a lot of families need to use that. In a nursing home scenario, very different. In New York, it's a $50 cap. So if there's a $4,000 income and you're applying for nursing home Medicaid, you're allowed $50 a month. Everything else goes to the facility.
Yeah, I mean, so in Florida, we don't distinguish between the two programs.
Okay.
We have a kind of an income number right now. It's $2,742 per month. That means you need to be under that income limit to just automatically qualify your income for Medicaid purposes.
Yeah.
If you are above that income limit, you can set up, we call it the qualified income trust. It's called Miller Trust for short.
Yep.
Doesn't have to be with a charity. It can be a private trust that you set up and have a spouse, a child, or someone else as a trustee, basically open up another checking account for your income to flow through to, so to remain eligible. And I don't know about, I mean, on our end, why I tell people this happens is because, we live in these income cap states where they say you can't make this much money and still be eligible for Medicaid.
Right.
But that was deemed unfair in the context of seniors who receive a Social Security check of $2,700 a month.
Right.
They can't change that situation. So this is kind of a court-derived procedure. But the good and bad is, so for these people who have no money but are over the income limit, still need a lawyer to help them draft this trust to qualify for benefit.
Good. And what was that amount again? 2,700?
This year it's $2,742 per month.
Okay. Whether it's home care or nursing.
Either way, yes. We do not distinguish.
Okay. Interesting. Okay. All right. Now, our next topic was to talk about the primary residence, but we already covered that. Now, if somebody has assets, and we kind of touched upon this also, how can they become eligible? Now, in New York, and this kind of goes into the next category of a look back period, so let's kind of tackle both of them at once. The home care in New York has never had a look back period. So if I have a client sitting with clients today, if they have a house in their name and if they've got $200,000 in their name, we're able to protect both of those assets in April, and that client will be eligible for community-based Medicaid May 1st, because community-based Medicaid still does not have a look-back period, and they haven't. However, that's changing. So as of right now, it's going to be March of 2024. New York Department, the Health Department has finally stated that they'll be instituting a 2.5-year look back. So it's going to be a 30-month review, a 30-month waiting period, a 30-month look back, if you will, to prevent people from protecting their assets in the last minute. Now, the purpose of the look back, just generally speaking, is so that if you do divest yourself of certain assets before applying for Medicaid, Medicaid will see that because they're going to look back at all of your assets. And in New York, they, depending on what region you are within the state, Long Island, for example, they say roughly for every $14,000 that's protected during that look back period, Medicaid will not pay for that care for 1 month. Okay, so that's roughly the calculation that the look back is used for. So again, home care, no look back for the rest of this year. What that means is if you have a need for care, get the protection done and get that community-based application service, get that taken care of. In a nursing home, and I believe this is going to apply, of course, to Aaron as well, it's a 5-year look back for New York nursing home Medicaid.
Yeah, so we, again, don't distinguish between home care and the nursing care program. But what's really unique in Florida is I like to tell people there's 3 big exemptions, right?
Yeah,
so one we've already talked on is that the house, right? So if you're living there, unlimited. If you're not, the 688 which goes up a little bit each year by inflation.
Yep.
The second and big one is IRAs.
Yep.
Which already any retirement accounts in payout mode. So if you came to us and you have a $1 million IRA, you have a $200,000 IRA. If you're over 73, you're already in payout mode because you're taking required minimum distribution. Yep. That entire asset is exempt, but for the income which we use towards your patient liability. And the third, and I think this is relates to spousal assets. So in the state of Florida, if your spouse has it's about $148,000 in name called the community spouse rule. That doesn't include IRAs. It doesn't include the house. You can still qualify someone for really any level of Medicaid. If you are living separately, so your spouse goes into a facility, assisted living nursing care, your spouse can have an unlimited amount of assets in their name, and that's called the spousal refusal Medicaid qualification. None of this is subject to the 5-year look back rule. So sometimes people come to us. They have $100,000 in wife's name. They both have IRAs and they have a house. And I'll say, we don't need to do planning. You're Medicaid eligible, which is kind of a crazy thing to have that situation here as well. I mean, and that's on top of really like if a couple or an individual wanted to gift assets into a Medicaid asset protection trust and use that as a plan as well. So for everyone, the situation is different. I think what I will speak to this briefly is that our home care services in Florida are limited. So even if you need 24-hour care at home, I know, our Medicaid program is usually going to set you up once you come off this wait list with like 20 to 25 hours per week of care. It might go up by a few hours each year, but there's not enough funding for that. So Brian, do you guys give full home care coverage in New York?
So definitely answer that question, then I'll go back to the other asset point. So what we find in community Medicaid right now is we're governed by what's called a managed long-term care system. So they're the ones that are allocating the hours and approving the hours. Generally speaking, depending on the care needs, we're going to have an hourly award somewhere between 5 and 9 hours a day. Okay. But 24/7 care is available depending on the needs. And so is what's called split shift. So you can have an aide with you for 12 hours awake with you, and then they leave and another one arrives for the next 12 hours. Very difficult to get, but it's certainly possible. Both Aaron and I, interestingly, the reason we work together on some cases is we both practice with what's called life care planning. So on staff here, I have a registered nurse and a geriatric social worker. So whenever we're dealing with those care issues, one of those care coordinators are going to be supporting that family and advocating for the hours of care, as difficult as it's going to be. But that's really what sets a life care planning firm apart from a traditional elder law firm. But yeah, we can get 24/7. It's hard, but we've got several clients with that now. To circle back to the asset side of things, so we do have some exemptions as well. The IRAs are exempt, as you said, as long as they're in payout status. Sometimes they force a higher payout, but that's a whole nother story. And there are exempt transfers, which won't ever be penalized, like you said, to a spouse. So, and in New York, we have the spousal refusal for the chronic care nursing home,
Mhm.
and we have spousal refusal for home care. So we can have an unlimited amount of assets transferred over to what's called the well spouse. They
Mhm.
sign a spousal refusal, and we're good as far as those assets being protected for the application. Doesn't mean that they're never going to be contacted. So the spousal refusal it's a double-edged sword.
Yeah.
So it's again, state by state, most certainly, not only the taxes we spoke about in the beginning, but long-term care and Medicaid itself is going to be based state by state. What's the eligibility for your home care Medicaid? Because in New York, we have to establish a need with 2 activities of daily living. Next year, they're going to be bumping it up when they add the look back period in March of 24. They're also going to be adding a 3rd ADL. So you have to
So
establish more care.
right. So what I always tell people that a big difference with our programs, the nursing home Medicaid, if you're in a facility and you meet the financial requirements,
Mhm.
and then we apply for Medicaid,
Yep.
you're going to get Medicaid for the month in which you apply.
No.
For the home or assisted living,
Yep.
unless you are already on nursing home care Medicaid, there is a wait list for services. And
Mm.
that's based on how much help you need with activities of daily living. Now, it's going to be a minimum of 2,
Right.
but the more help you need, the
Sure.
more, the quicker someone is going to come off that list so that we can actually apply.
Wow.
So we have to go through a process with them.
Mhm.
We tend to find age plays a factor. If we have someone in their 90s, they're going to
Okay.
come off the list sooner than someone in their 70s.
Interesting. Okay. So I think we've covered a lot of great topics, not only, how to prove the domicile, the estate taxation, the difference between the estate planning documents and probate, the irrevocable trust and long-term care itself. What I'm going to share now as we start to wrap up and start looking at questions is let me put up here our contact information. We hope that you enjoyed this. I think that this was a great topic, and I think Aaron and I kind of played it into each other very well as far as the topics, because I'd cover this and then he would counterpoint with that, and hopefully you found that helpful. Now, we're based in Melville and Riverhead, in on Long Island. We of course work most of downstate in New York City, Westchester County, etc. TullyElderLaw.com, TULLY elderlaw.com is our website. And Aaron is down in Boca Raton, and as he said in the beginning, he can work and help families throughout the state. Millman Law Group, Millman, right? Law Group,
Yep.
2 L's,
Yes.
is the way to contact him, and his phone number is there on the screen as well. So while you folks copy that down, let me look at our questions here. Now. Okay, so we have a question asking about Arizona and New York and Florida. And Debbie, I'm sorry, you might have to do one for Arizona. I'll have to get another attorney
Yeah.
to look at as far as those laws. Every state, when you look at taxation and long-term care, is going to be different, as well as the estate planning documents. Another question, if I need Medicaid tomorrow, is it too late to protect my home? So that's going to depend, right? Aaron, in Florida, you've got the look back for both home care and nursing home care. Is that right?
Right, but if you're home, again, wherever it is,
Yep.
it's exempt. If you don't live there, if you're it's up to $688,000 of one residence in any state, basically.
Yeah. So it's going to be fact specific, Gene. And as we've learned both in New York and Florida, if there's a spouse, things can get moved to that spouse last minute. In New York, the only way you can save your house without a spouse is if it's home care. And that's only for the balance of the year until they implement the look back period. Next question. While you may be under the New York estate tax exemption amount, if you have an irrevocable trust on New York property, the trust will still owe capital gains in New York. So a lot of that norm is going to be based on what type of trust you're looking at. The Medicaid Asset Protection Trust that we've been talking about here is what's called a grantor trust, and it has different tax provisions so that the family will receive a step up in basis if it's that Medicaid type of trust. However, if it's an estate tax based trust, you're not getting that step up, but rather the family will have to deal with the capital gains. Is that similar in Florida, Aaron, right? You get the step up.
Exactly. Yeah. I mean, we didn't talk about this, but it's more of a tax side. When you own
Sure.
assets in your name, your revocable trust or a Medicaid trust, you can get a step up in basis of death, which would eliminate the capital gains.
Yeah.
But generally, if you're just selling a property with capital gains during lifetime,
Yeah.
the trust is going to pay that unless it's a grantor. Yeah.
Yeah. Yeah. Good. It's very similar. I am widowed. Should I add one of my children as a signer on my bank account? So generally speaking, I'm going to say yes to that. Depends on the child, depends on how much money's in there. Again, it's factually dependent. If you have a child with issues, if there's a divorce pending, if there's addictions, if there's other concerns, you got to be careful, right, Aaron? You'd say the same thing.
Exactly. And just keep in mind, a signer is basically equivalent to like being a power of attorney on that account. Signing authority goes away when someone passes away. So make sure you have beneficiaries on that account as well to avoid probate.
Yeah, good point. Next question. So if you qualify for Medicaid in New York, how can you then qualify for Medicaid in Florida? Aaron?
So there is no reciprocity. I mean,
Right.
basically, even though Medicaid, people think of it as a federal program, it's been administered by the state since like 1965 when it came out. So being on what I always tell people, especially when they are moving like to New York, I'll say, before you bring someone or you go, talk to an elder care lawyer, a couple of months before you go, see what you can do to start that process, because there is no reciprocity. We don't just take you because you are on programs.
Yeah. I was talking to the son of a prior client yesterday, starting into getting to the Medicaid conversation because there's a need for care. And then we learned that the plan is to move mom to Florida. So at that point, just wait to get there. It's not worth undertaking New York Medicaid and then moving and doing the whole Florida process. Every state's going to be different. Next question, does VA cover spouses of the vet? And in New York, it's for the veteran himself or herself. And if that veteran is deceased, then it is for the surviving spouse. Same thing, Aaron, right? It's national, it's federal.
Yeah, exactly. And VA, although, and not to be confusing, is a federal. There's nothing going to be different about New York or Florida there.
Right.
So you've got surviving spouse benefits are about, I think the maximum is like $1,200 to $1,300 per month on the VA.
Good.
And if the veteran is living, there's a little bit more money if the spouse is the one in need of care.
Yeah.
That is called the Veterans Aid and Attendance Pension Program, which is what we've been talking about and deals with basically not a vet being disabled during war, but they are disabled now. They require help with activities of daily living.
Right. Not necessarily service connected at all.
Correct.
Right. At what age should you begin to protect your assets, houses, bank accounts? So just as a general rule up here, and I'd love to hear what you have to say, Aaron, too, is we focus at 65. Well, I'd like to say when you get your Medicare card, that's when you should be having your, what we call an elder care protection plan. You should have the asset protection trust. It used to be 70. We used to focus on families over 70, individuals over 70. But then back in 2020, they started talking about the look back period for home care. So we've pushed it back to 65 years of age. When do you start talking about it with your clients, Aaron?
I guess I don't have a specific age. I like to say 65 to 75 is probably a good time to look at it. We get a lot of people down here who did wills when they had children who were 8 and 12, and now they're 40 and 47. And we just wanted to, we bring in this into the discussion. Again, sometimes we're setting up a plan for this.
Lost you. We were doing so good, Aaron. All right, it's 2:11. We went a little bit over. We lost Aaron here. If he comes back, that'll be great. Next question is, I have community care in New York, but the co-op is not in a trust. Will Medicaid take the co-op? The answer is they might. If in New York, if a person passes away with an asset in their name alone, there's something called estate recovery. If it's your primary residence and you move out, perhaps assisted living or nursing home, then Medicaid can put a lien on that property. He's back. All right. It was a specific New York question. I just covered that. Next question for you, Aaron. Can you assist with finding long-term care in Florida for a parent that requires it? You're still on mute.
Sure, we help people with that all the time. I mean, that's a big part of what we do. We help locate appropriate care, whether that's, assisted living, skilled care, getting the estate planning or elder care, and helping with benefits planning if that's necessary. So yeah, please reach out. We can absolutely help there.
Last question, and it's going to be for Aaron. In Florida, what is reserving enhanced life estate? What an enhanced life estate? What is that in Florida?
Okay, so enhanced life estate is the technical term for a ladybird deed. A ladybird deed came out of the case Ladybird Johnson. The simplest way I can explain it is a transfer on death deed. So let's just say you don't have, you have every single asset or account has a beneficiary on it. Some people say you should do a ladybird deed on your house. And that is another way to avoid probate. It's a simple form to do it. We're basically creating a transfer on death deed for 1, 2, 3 children.
Right. I
I like to do that if there's no other assets needing to go to a trust. However, if you have 4 children, I'd rather not do a ladybird deed because then they each become quarter owners of a house. And if they don't get along, how are things going to get done or paid for? I'd rather see it part of a trust. You put one child in charge, they sell it, and then give everyone, their money. So it's an estate planning tool, but depends. And so it's called and we help people with that too.
Yeah. Perfect. So in New York, we call that a life estate. And for the same exact reasons Aaron just mentioned, because it makes sense, is we don't use them a lot. In the example of the 4 kids, if even one predeceases the parent, now what? Now you've got that sister-in-law or son-in-law and perhaps minor children involved. It can get very messy. There's no contingencies, it sounds like, in a ladybird or in a life estate situation. So a trust is usually much better. So that's the end of the questions. I'm going to say thank you all for joining us. It's been a real pleasure to have you. Make sure you get on our email lists, all right? So you'll learn about these webinars. If you got to us through Facebook, reach out, let us know you're around and get on the mailing list. Aaron, thank you. I think it's been great.
Yeah.
All right. No, I think we should do this. I'm not going to say every quarter, but maybe once or twice a year.
Yeah, no, it's important. I mean, we always offer the service again, and Brian probably too, to take a look at your prior documents, see if there's anything we need to do, how we can help and provide guidance, and just have a contact, whatever state you decide to, make your permanent residence as well.
Very good. Very good. Again, thank you, Aaron. Aaron, thank you everybody else for attending. See you soon.
Thank you all. Bye-bye.
Bye-bye.